Kia ora to committee. As you'll know, I'm a Professor of Law at Te Waka, Victoria University of Wellington, specialising in constitutional and government law. And can I start by saying that it goes without saying that under the principle of legislative supremacy, Parliament has the authority to legislate to override the common law, as it seeks to do so with this bill here. The question, though, for the committee and the House is whether the exercise of that legislative authority is appropriate, wise, and properly respects other constitutional principles and traditions. My submission is that it does not, and the bill should be rejected or amended, especially to carve out and save Smith's current proceedings. And the 2 points I make are interrelated, one on matters constitutional, one on the underlying policy. From a constitutional perspective, and I start with those concerns, nullifying Smith's current common law claims is objectionable, constitutionally objectionable, because the retrospective effect of nixing the claims undermines the rule of law, because interfering with the judicial process in this way is contrary to the separation of powers and breaches the principle of comity, because taking away Smith's day in court is contrary to his right to justice, and because not preserving the fruits of any victory is contrary to the usual traditions of fairness as reflected in our practice of legislative design and quality. And as an aside, if this bill was introduced 2 days later, once the Regulatory Standards Bill had taken effect, as Professor Rive explained, we would have had a very grim consistency accountability statement admitting to breaches of the principles of the rule of law, good lawmaking, and responsible regulation. Now, if I turn to the policy underlying the bill, the putative rationale is weak and premature. Claims of a need to override the common law to ensure regulatory coherence and to confirm the executive and the legislature's role of developing and setting and implementing regulatory policy are, in my view, dubious and overstated. The short point is that legislation and the common law can generally, and can in this case, work in tandem. Concurrent legislative and common law regulation is not unusual, and I instance a couple of examples in my written submissions. And importantly too, here, the current statutory regime does not cover the field or speak to the damage to individuals the common law claims seek to address. In any event, the nature and reach of the current common law claims are not yet known and still face some hurdles to be realised, and you've heard some about that earlier. The strongest prospects, in my view, lie with the existing and well-established tort of public nuisance, as addressed heavily by the Supreme Court in its ruling. I think the so-called novel claims of climate change cause loss has very low prospects for success. And you've heard also about the prospects of different relief from earlier submitters. And here I caution about being distracted by the novelty of the latter. I think that's a red herring. The principal basis of the claim is in public nuisance and involves the application of pre-existing doctrine to past facts in the usual way that the common law adjudicates in tort claims. Importantly, the weak and, in my view, wafer-thin policy basis for nixing claims means there is insufficient justification for departing from usual constitutional expectations about not legislating over top of live court proceedings. And in my view, the bill should be rejected. But if not, as a minimum, Smith's current proceedings should be excluded from the proposed statutory bar. And I've also floated, if that's done, whether the statutory bar itself should be time limited in order to allow the effect of Smith's claim to be reconsidered once it is determined. Finally, can I close by recording my concern about the expedited lawmaking and select committee process? It's shoddy lawmaking, unjustified procedural and participatory shortcuts without justification that has become all too common and I think are a stain on our democracy. Kia ora.
Thank you very much, Dean. First question from Carl Bates.
Thanks, Chair. Thanks, Dean. In your experience, what would the cost of a court case like this generally be to the defendants?
Oh, it's been over 2 decades since I've been in practice. The costs will be commensurate with the degree of the claim, the complexity of the claim, and those sorts of things. I couldn't offer a view on that.
Okay, fine. And in your understanding of the sort of outcome that could be achieved if the defendant was to lose, what do you see as the potential costs to that company?
I don't know. I mean, I'm not a. I mean, you've heard some earlier submitters talk about the likelihood or the possibility of particular remedies being granted or not. There's obviously the hurdles of liability first. I don't know. We don't know because that hasn't come to pass. It's all premature. But I expect that it's not as grave as some of the hyperbole that's been suggested here earlier.
Okay. The final question, if
How many?
we don't know those things, then isn't it entirely appropriate for Parliament to say, we don't want to take this risk, we don't want this effect to occur on the New Zealand economy, even if it's slim, and there's two very different sides to that argument. Isn't it entirely appropriate for Parliament to say, we're going to remove that risk so that we can actually focus on doing the work to reduce climate change effects in New Zealand?
Well, I guess my submission is that the constitutional costs of doing so well outweigh that risk, and the best thing is for let the case to run, and then allow the courts and the Parliament and the Executive to be in dialogue about the nature of responsibility for these types of liability.
Thank you, Carl. We'll go to Dr. Duncan Webb, and that'll be the last of our questions.
No, thank you. I really only have one question. It's around the idea of a citizen having the right to litigate a claim in the civil courts and the concept of a right to justice. You alluded to it, but I think it's actually at the core of your objections. Can you just expand on the concept of a right to justice as a foundation of the rule of law and why this case is particularly problematic?
Yeah, well, I mean, I think it is one of those high points of the right to justice, and that's part of the rule of law, the ability to go to an independent courts to ask for the law to be tested, to be adjudicated based on past facts. That's a fundamental feature of our rule of law, ensuring that we're a rule-abiding society and so forth. And it's been fundamental. I know that that, for example, when the Labour government legislated away the foreshore and seabed claims several decades ago, that there was quite a bit of opposition from the parties in government who are now promoting this bill. So it's a well understood principle that there's a procedural and substantive aspect of the ability of someone to go to a court and ask, the law should be supreme and should be applied here.
So what constitutional position we ended up with if governments of any colour legislate to whenever they don't like a piece of litigation?
Well, it becomes lawless, because the law that can be applied will be the whims of Parliament. And one of the ideas of the rule of law as a system is we have a system of laws that should be faithfully applied, and people should have the benefit of that. And the benefit of processes like independent courts will allow that to be adjudicated and held to be applied.
Thank
you very much. Thank you, Dean. Really appreciate